Morning, everyone. Just loading the PowerPoint presentation. All right, thanks for joining. Today we're going to talk about hopefully an interesting topic, which is interpretation of the BE codes. I think the reason we want to do this is to sort of highlight a few things that have come up, certainly in our experience in relation to interpretation, and try and sort of give people an insight into how one goes about interpreting the codes. We're going to be focusing on generic codes, and we're going to look at some of the legislative prescripts as well to get a sense of what it is that we need to look at. So without further ado, let me get into that. The first thing we're going to talk about is just the general BEE, triple BEE regulatory environment, in particular what the triple BEE laws entail. Now, I think I've mentioned this before in other presentations, but the most important point is that the Triple BEE Act is primary legislation. It's the one that deals ostensibly with all Triple BEE initiatives in the country, but it's not the only piece of legislation. There are other laws that also regulate Triple BEE in some form or fashion. There are sectors that are not necessarily aligned with the Triple BEE Act, although they have their own Triple BEE prescripts. I mean, industries like mining, fishing are good examples of industries where there's not adherence in every respect with the Triple BEE legislation, but they also contain provisions which regulate Triple BEE. We're going to be talking about the generic codes in this presentation in particular. I'll deal with it in quite a bit of detail, try and get an understanding of what the codes are and what the relevant aspects of them are and what we need to look at. We're not going to talk about sector codes, but it's important to, or we're not going to talk about any specific sector code. We will talk about sector codes in general. They're quite important because they govern sort of various sectoral parts of the economy and have the same status as the BEE codes, but we'll talk about that in a bit more detail. The other thing is there's a lot of notices and clarifications and guidance notes, etc., which have been issued under the BEE Act over the years. We're going to mention some of those. In particular, we'll talk a little bit about a practice note that was issued by the DTIC in 2019, which is quite important for purpose of this discussion. Okay, I want to talk a bit about the regulatory environment and what I call the overseers of Triple BEE. Now, if overseers is not necessarily the regulators, but these are all the sort of regulatory type bodies which govern and enforce Triple BEE. Starting point is the Triple BEE Commission. That's a statutory entity created under the Triple BEE Act. It is primarily responsible and the primary regulator for Triple BEE in the country, but the DTIC is also still involved in Triple BEE. It's obviously in a sense the legislature, although that's actually Parliament. It issues guidance notes from time to time, which are often binding, and it also is the entity that publishes codes from time to time. Then you also have the BEE Advisory Council. The BEE Advisory Council is actually like a presidential task team. As its name implies, it's set up to advise the DTIC and around issues, and the minister and the presidency around issues relating to Triple BEE. It's not really a public-facing organ, but it's in the background largely responsible for assisting and advising on policy interventions required. Then we have verification agencies. Now these are not regulators. These are the ones that actually end up doing BBEE verification. They're probably the most important cog in the Triple BEE regime. And they're the ones who actually issue the certificates which everybody relies on for purposes of Triple BEE compliance. Okay, then sector charter councils. Now these are the entities set up under the sector codes. and they're responsible for monitoring and implementation of BBBEE under sector codes. So there's quite a lot of them. There's a lot of sector codes out there, and these are the bodies that will ultimately be the ones that participants in sector council or stakeholders in sector charters or sector codes will actually report to, and those prescripts that they indicate, and they'll also issue guidance notes, etc., from time to time to govern BEE compliance. Okay, so I want to talk a little bit about fronting and fronting practices, and the reason is it's come up quite a lot in the course of certainly the last few years, as BBBEE is sort of gaining prominence in the South African economy. I think it's important that we understand what is a fronting practices, what is a fronting practice, and what are the offences under the Act, and when one must take a view as to whether or not a fronting practice exists, and also to sort of try and clarify, when does a fronting practice occur. So as I said in the beginning, the BBBEE Act is not the only piece of legislation that's governing BBBEE. There are other laws, and if you look at the definition of fronting practice and the Act, you'll see that it applies to any initiative under any law promoting BBBEE. So it's not just fronting specifically under the codes or under the BBBEE Act, but it could also be fronting under any other piece of legislation. Now, these are the key words in the Act, in the definition of a fronting practice. The first requirement is it must undermine or frustrate the achievement of the objectives or the implementation of the provisions of the Act. Now that's quite an important starting point when one tries to consider what is a fronting practice, because there's obviously some intent to actually undermine or frustrate, as opposed to really just always looking at the facts and circumstances which may arise. Bear in mind, it is a criminal offence, so there is intent, but it's slightly different intent in the ordinary sort of criminal sense. We'll talk about that a bit later. But the key thing for most people to understand, and I've seen this quite a bit when for example, BBBEE audits are conducted. When people look at what is fronting and whether a fronting indicator exists, there's a tendency to look at the examples mentioned in the Act as to what constitutes fronting, and then try and consider or determine whether or not those indicators exist. There's a few problems with that. The first is those are examples; they are indicative, but they're certainly not exclusive, and they're not determinative. They're not exclusive in the sense that there could be lots of other basis for which a fronting practice can occur, and nor are they determinative, because even some of the circumstances mentioned or some of the examples mentioned may not in themselves be a fronting practice, because you must go back to the purpose of the legislation, and particularly the definition. And if there isn't any intention to undermine or frustrate the objectives of the Act or the implementation of the provisions, then it cannot constitute fronting. Maybe just to mention some of the examples, there's actually 4 examples with some subs. I think one of the first ones is that if you appoint a black person to a position, but that person is discouraged or inhibited from carrying out the duties that would have normally been assigned to them, that could be regarded as fronting. Also, if there's economic benefits that do not flow to the people in the ratio indicated in the legal documents, that could be an example of fronting. And then the other one is including legal relationship with black people, but you don't grant them the economic benefits which would reasonably associated with the status of the position held. And then the other key example is conclusion of agreements with another enterprise, but where those agreements have significant limitations on the identity of suppliers or the service providers or the clients or the customers, etc., or where the maintenance of business operations is reasonably considered to be improbable, having regard to the resources, and then also where the terms and conditions are not negotiated on an arm's length basis or a fair and reasonable basis. Now the last one is actually quite important, because one of the underlying principles is that if you do an agreement with somebody and there are good commercial and reasonable reasons why particular provisions are included in the contract. Even if on the face of it, those appear to be contrary to BEE, it's not necessarily so. The reason is that it has to be specifically something. It has to be something that specifically, undermines or frustrates the objectives of the act. If it doesn't do that, and if there's good sensible reason for people to actually implement certain measures, then those are not necessarily fronting. It really turns on the facts of every particular case. Okay, let's just talk a little bit about the offences, because there's sometimes some confusion about this. So the first point is it's quite a dire consequence for committing a fronting offence. There's a fine or imprisonment of 10 years. And if the fine is in relation to a juristic person, it's up to 10% of the turnover. Misrepresenting your BBEE status can also be fronting, but it's a specific and separate offence as well. So while I would suggest that misrepresentation of your BBEE status is definitely fronting, it is a separate offence. So it's not only fronting. The other offences are misrepresenting information to your verification agent or the state or the public. That's also a specific offence. And then verification agencies who fail to report an offence or attempted offence is also criminally liable, perhaps not to the same extent as the 10-year imprisonment or 10% fine. So key thing about the definition and whether or not the offence is committed is the definition of knowingly, because you only become liable for an offence of fronting if you knowingly commit that offence. Now, knowingly means not only having actual knowledge, but also where you reasonably ought to have obtained actual knowledge. Now, that does impose a duty on everybody to actually, if there are circumstances in which you should be interrogating a particular transaction or a particular dispensation, you need to be able to do so. Because if you don't do so and you say, well, I didn't know or I shouldn't have known, that's not necessarily going to be, a good defense. In fact, this particular offense, and it's not unusual, we see it in other legislation, it's not just purely proving intent. It's an objective or reasonability test applied, so that if you think that there could be something or you reasonably should have considered something, then you need to do it. Otherwise, you can still be held liable for fronting. I mean, it's probably just an extension of the old principle of law that you cannot ignorance of the law is not an excuse, but this one probably goes a bit further in the sense that you can't it's not just ignorance. You actually have to interrogate facts and circumstances. You can't just get out if you think that you shouldn't have known or you don't really have a duty to look for it. Okay, then the other important clarification is that where you're complying with the act and you're applying a reasonable interpretation, that's not necessarily fronting. As I said before, even though it might, on the face of it, fall into one of the examples of a fronting indicator, it doesn't mean that it's necessarily fronting, because unless there's an attempt or you knowingly undermine or frustrate the achievement of the objectives or the implementation of the act, then it's not in itself going to be fronting. Okay, I want to talk now about the codes, and specifically the generic codes, and I think it's important that we try and understand the structure of the codes and what they are. I think many people refer to the generic codes quite loosely and think it's really just it's only just the 5 elements and the statements that set out those 5 elements: your ownership, your management control, etc. But it's actually a lot more than that. There's a set of codes and a series of numbered statements. I'm going to go through each of them. Some of them I'm going to discuss in a little bit of detail towards the end, but I'm not going to discuss all of them. There's too many. So let's start with the first one. It's code series 000. This one is actually very, very important because this sets out the general principles of interpretation. We're going to discuss this one in a little bit of detail in a few minutes, but it's most people don't, I think, appreciate that this is part of the codes and this is a code on its own. And when looking at any of the other statements, you specifically have to consider this one. I'm indicating the dates in brackets next to each of these because There's different dates. BEE started, well, the codes were first promulgated in 2007, or around about there, and then they were amended in your 23rd from 2013 onwards. And we're talking about the amended codes now. This specific code 000 was amended in 2019. So there are other versions of it, certainly under the 2007, but under the 2007 codes. But this is the latest version, and this is the one you need to apply when you're looking for it. Then we have a few others under statements under code series 000. So the first one is 003, and this is the guidelines for developing and gazetting of sector codes. This was promulgated in 2015. It's also later than than the old ones. There was previous versions of this one as well. We'll talk a little bit about this when I'll talk something about this, because this is quite important to look at when considering the scope of application of sector codes, and also what are the rules around sector codes and how do the sector codes relate to the generic codes. That's quite an important principle, because the generic codes are more than just a set of codes that govern the implementation of BBBE generally in the economy. They also are limited by the generic codes, and the generic codes in essence are the codes that one must always look to at first instance, because many of the definitions and many of the requirements in the generic codes apply in any event to sector codes. We also talk about, well, I'm not going to talk specifically about sector codes or statement 004, which is the scorecard for specialized enterprises. Now, specialized enterprises are enterprises that cannot evince ownership. Okay, and those would be state entities where the state is not black for purposes of BBBE. So any organ of state, particularly public entities, wouldn't be able to be measured on the ownership element. So this particular statement sets out the requirements and the scorecards for entities where you cannot evince ownership. It's not just state entities; it also includes what we call NPCs now. It used to be Section 21 companies, but those were companies limited by guarantee under the old Companies Act. It's now been changed. We don't have companies limited by guarantee anymore, but we do have companies where there are no shareholders. So where you have an entity or legal entity that doesn't have shareholders, so it's difficult to indicate who the owners are, you would apply this particular statement. The other important part is from state entities perspective, all public sector entities can be measured, particularly public companies or public sector companies can be measured for BEE and should be measured. In fact, they are obliged to comply with the BBBE codes, and this is the scorecard that will have to be applied for them. Okay, statement 005 is probably a lesser known statement. It's an odd one in the sense that it wasn't really amended in the rounds post 2013, 2014 when one was changing or amending the generic codes. This one still refers, the last version of it was 2011. It still refers to the old codes. It also still refers to IRBA, for example, being a regulatory body. That's no longer the case. It's only SANAS approved verification agencies that are now allowed to do verification in the country. It's quite an important a particular statement to look at. It obliges accreditation for verification agencies, but it also requires them to apply what's called a verification manual. This document, the latest version of it is 2015. It's also a bit of an odd piece of legislation in that a draft was published sometime in 2015. It was never really a final draft was never published. So, but it's not been repealed. So statement 005 has not been repealed, and the verification manual has not been repealed. It does sometimes still refer to old code concepts, but it, as I understand it, it is the document that is used by verification agencies to guide them in doing the verification exercise. What is important about this document is it sets out quite a lot of detail around how one should go about doing BEE assessments. And it's an obligatory document, and all verification agencies must comply with it and must, as a minimum standard, apply the verification manual or the requirements in the verification manual. In fact, goes so far in statement 005 to say that if they don't apply the verification manual as a minimum standard, that scorecard can be set aside, or the verification certificate can actually be set aside. The other important thing about statement 005 and the verification manual in particular, it specifically deals with fronting, and it requires all verification agencies to assess and look at fronting in particular and to determine whether or not a fronting indicator exists. That would mean that when you get a BEE verification certificate, you, as the person relying on that certificate, should be entitled to accept that there has been an assessment as to whether or not the entity involved has been involved in a fronting exercise. Of course, in real life, it doesn't always work out that way. So one must always look at these things a little bit critically. But the reality is that this is the job of the verification agency to consider whether or not a fronting practice may exist, or there are indicators for fronting, and it should not issue a verification certificate under any circumstances if it's concerned that there are fronting indicators present. Now we get on to the statement, and these are the ones people are more familiar with. You've got the ownership element, which is Code 100 and Statement 100. We will talk a bit about that. There are quite a lot of things in there which do lead to some interpretive issues. So I think it's important that we clarify some of those things. Under Statement 100, you've got Statement 102, which is the recognition for sale of assets. These are part of your deemed ownership mechanisms under the Act. So for example, if you sell a business to Black people, you can claim the ownership points as a result of that, basically based on the percentage of or the value of the transaction relative to the percentage of your business, and you can then without actually having any actual Black ownership, by virtue of selling assets or selling a business to a Black owned entity or to Black people, you could also claim ownership points. It's become quite popular, especially for larger enterprises who have lots of businesses and are looking to comply with BBBEE, but don't necessarily have the capacity to do actual ownership deals. This is quite a useful one to use. Then there's Statement 103. This is the recognition of equity equivalence for multinationals. This is the rule that says that where you're a foreign multinational entity and you are precluded from implementing any kind of Black ownership transaction due to your own internal rules or your governance principles, then you can apply to DTICC to have an equity equivalent program in place. Essentially, it involves you making some kind of financial and other contributions instead of actually giving up any ownership or equity in the entity. It also sets out, this particular statement also sets out the rules for multinationals and when one can exclude them. Statement 200 is the measurement of the management control element, and this is the one that also replaced the old code's employment equity or provisions. It now deals with all forms of employment, particularly management employment in measured enterprises. Then we've got the skills development scorecard and statement. That's Statement 300. That one's, you'll see that those ones are also dated 2013. So those were the first ones. So the ownership, all of the statements here you'll see came out in 2013. They haven't been changed. So those are still the ones that are applicable. Enterprise and supplier development, also still the 2013. That's the measurement of enterprise and supplier development. Also includes preferential procurement. We will talk a bit about that one in the codes, because that's quite a topical one, and there are lots of little nuances and rules around that I think we need to have a chat about and discuss. And then lastly, we have statement 500 of the formal codes, which deals with socioeconomic development. We're not really going to talk about that. That one is pretty straightforward. I mentioned for completeness, statement 600. Now that's for QSEs. Those are entities which have a turnover of up to 50 million rand. That one was also revised, and 2015 is the latest version of that particular document. And then the other one, which I thought just for completeness sake, is Schedule 1, which is the actual definitions of terms used within the codes, which sometimes people forget that they are actually defined terms. It's not always very consistent. The definitions in the codes and the schedule don't always marry, but it's important to always have a regard to what those definitions are when applying an interpretation of the codes. Okay, let's talk a little bit about statement 000. The first principle that statement 000 makes clear is that substance takes precedence over legal form. And now it's a general principle in our law. It doesn't mean that in all cases one disregards the legal form, because sometimes the legal form is in fact the substance of the particular transaction. But what it is important in is, for example, when one considers whether or not the fronting indicator has happened or taken place, you would look at the substance of the transaction. What is actually happening? It's really a very important principle, which I think a lot of people forget when they get stuck on legal transactions and they get stuck on the form of the transaction and don't really look at, well, in substance, what is it trying to achieve, or what is it actually all about? The other important principle in statement 000 is that any reasonable interpretation consistent with the objectives of the BBBE Act and the BBBE strategy must take precedence. Now, the BBBE strategy is a document that exists. It was issued quite a long time ago. It hasn't really been updated, and the version that I have is actually a little bit incomplete. But that document is not really, to a large extent, a lot of what is contained in the BBBE strategy has been encapsulated in the Act. So it's not, I don't think it's going to have much relevance in interpretation. But key point for this interpretive principle is that your interpretation must be a reasonable one, which is consistent with the objectives of the Act. It's useful to look at what those objectives are. So the first objective is any initiative must promote economic transformation to enable the meaningful participation by Black people. Now, those words are important. I mean, meaningful already gives you an indication that, what he's trying to achieve is something not just ancillary, but actually a meaningful disposition, which if you don't, it comes through largely in the context of when one looks at whether or not there is actual ownership. We'll talk about ownership, for example, in statement 100, but this objective, I think, guides us as to why there is an emphasis on looking at substance, for example. The other objective is the intent under the Act is to achieve a substantial change in the racial composition of things like ownership, management, and skills. Those three, ownership, management, and skills, obviously are encapsulated in statements themselves, and you see they feed through to the general interpretation as well. The other objective is to increase the ownership and management by Black women and collective enterprises. Those collective enterprises, I'm talking about entities like broad-based ownership schemes, employee share ownership plans, and other vehicles where you have you don't have direct ownership, but you have indirect ownership through these entities. Then the other important objective is it's about promoting investments that lead to broad-based and meaningful participation. Again, the word meaningful occurs. And now we also see another objective which also ties through to the preamble of the Act, which is ultimately to achieve sustainable development and general prosperity for all people. If you look at even the preamble to the Act, it specifically says that because of the historic imbalances in the country and the fact that largely Black people weren't given adequate access to economic opportunities in the country, there is a need to take further steps to increase the effective participation of the majority of South Africans. And the point is the stability and prosperity of the economy would largely be dependent on this. So that's an important principle, because BEE is, or triple BEE is while it's directed at increasing the extent to which Black people and Black designated groups in particular participate in the economy as a whole, the ultimate aim is to try and achieve a prosperity for the economy as a whole, irrespective of race. And then the other one is, the other objective is to empower rural and local communities. So that's a key feature of the changes that were introduced. Initially, BEE was looked as a bit too narrow, focused on certain well-connected Black individuals. So increasing the base of people, particularly looking at rural communities, local communities, and providing opportunities for those was a key feature of the legislation, and remains so. And then finally, to promote access to Black startups and other small entities, and then increasing also the economic participation of smaller entities. Okay, startup enterprises versus EMEs. So let's start with the EME. An EME, exempt micro enterprise, an entity with a turnover of 10 million, of up to 10 million. So 10 million or less. A startup enterprise is deemed to be an EME, but it doesn't matter what its turnover is as a first principle. So the rule is, and this you'll see this in the definition section in Schedule 1, it's an entity that's been in existence for less than a year. It's a newly incorporated entity, but importantly, it doesn't include an entity which is a rollover, or an entity which is essentially the continuation of an existing enterprise. So you can only really use new entities. It doesn't matter what the turnover it is, what its turnover is, to constitute a startup enterprise. It's got limited application, but it is deemed to be an EME. But I sometimes see people, taking entities that have been, so for example, you reconfigure an entity, use the same legal entity, but you change its business or you sell it, so now you think it's a startup. It's not a startup. A startup is only a newly created enterprise. It's not an entity which is a continuation of an existing enterprise. Okay, so let me set that. Okay, so the statement also talks about the deemed recognition requirements. So it provides that QSEs and EMEs, which are 51% Black owned, must apply what's called the flow-through mechanism. Now, the flow-through mechanism, we'll talk about it a little bit more in the context of Statement 100, but essentially that requires you to trace the Black participants, as opposed to the modified flow-through, which we'll mention again, which is where if you have an entity in a chain which is more than 51% Black owned, it would be deemed to be 100% Black. So this one I see often in practice, people forget that you have to be able to trace 51% Black ownership first. And you have to apply the net value, sorry, you have to apply the flow-through principle. The requirements for 51% Black owned are three things. One, there must be 51%. I'll mention it again later, so we get it right. But you have to apply. You have to have 51% of the voting rights. You also have to have 51% of the economic interest, and then importantly, you have to earn all the points for net value. Net value being the last aspect of the ownership scorecard, which essentially measures the difference or the net value, if you can call it that, of an equity instrument held by Black people. So what it really does is it looks to disregard or take into account any acquisition that's associated with the Black equity holding. There's also in Statement 000, there's a requirement or a specific statement that says that all startups, ENEs, and QSEs, where you are tendering for a contract of 50 million plus, bear in mind the threshold for QSEs is 50 million. Then you must apply, if you're an EME, you must apply and it's a contract up to 50, you must apply QSE scorecard. And if it's a QSE applying for a tender more than 50 million, then you have to apply the large scorecard. The difficulty with this particular provision, it's really difficult and to a large extent, I think, impossible to apply, Because at the point, if you're an EME or you're a startup, it's a better example. If you're a startup and you're tendering for a particular contract and the value of that contract happens to be over 10 million or over 50 million for that matter, you can't really do a generic or QSE scorecard, because all of the data that goes into deriving a scorecard is based on historical information. So you need to look at your financial performance, and you obviously need to make sure you meet the turnover thresholds. So while this provision exists in the codes and is often, you often get queries about it, but it's really very, very difficult to apply this particular provision, because you can't. I mean, it's how do you measure yourself when you actually don't have that turnover, and you cannot comply with any of the elements, because you actually just never historically done it, because everything in round B is measured with reference to initiatives you've taken in the past, not for stuff that you're going to do in the future. So it's largely I don't know, it's a difficult one to actually apply. I don't know how and to what extent people actually can apply it, but it's there, it exists, and it says that you have to do it. But yeah, it's one of those that I don't know how we actually do it. The other one I want to mention is consolidated BBEE scorecard. This was a construction in the 2007 codes, which allowed group companies to do one BEE certificate at, say, for example, holding company level, and that could apply to all of their subsidiaries. The particular enabling provisions used to be in the old statements, 000, I think it was, under the 2007 version, but it's been removed in the amended version. So the 2013 versions onwards don't actually refer to it. I do see in practice that often you'll get triple BE certificates, which as an annex contain a list of subsidiaries to which those that scorecard applies. Now, consolidated scorecards are mentioned. The only reference I found to them in the current codes is actually in the verification manual, where there is a specific reference to that and how you should be able to apply the principles around that. It's again one of those things. I'm not sure it's right, or put it this way. I don't think you can take a BE score of a holding company, considering that applies all the elements of ownership, management, control, skills development, etc., and then simply apply it on the same basis to every single subsidiary. It's true that you can, if it's a wholly owned subsidiary, the ownership will be the same across the board across the entire group. But when it comes to things like your skills development, your enterprise development, etc., that is dealt with at company level. So while companies, I think there's no issue with them including a list of subsidiaries, we have to bear in mind that each legal entity, as a general rule, needs its own scorecard, because the compliance of all of the other elements, not just ownership, have to be evidenced. And even if one looks at the verification manual, which does provide for this, you do see that they do indicate that there's different ways to measure other companies in the group. While ownership can be inferred, the rest of the elements are actually measured separately. Okay, statement 003. So this deals with the setting up of sector codes, and is the guiding document which must be applied particularly by DTIC and other ministerial entities when developing, not other ministerial entities, the ministers of other government departments and stakeholders when deciding to put in place a sector code. So the first important principle is that the statement 003 makes it clear that all sector codes must use the same definitions in respect of beneficiaries as set out in the generic code. So beneficiaries here would mean, I think, including the ownership of beneficiaries, and then beneficiaries in the context of things like enterprise and supplier development, where beneficiary entities are specifically identified. We can talk a little bit about that under the ESD scorecard requirements. And the other important point is that they must use the same calculation methodologies to measure compliance. This is quite important. Because you do see generally this happens, but sometimes not necessarily so. And it's an interesting point, because if these are requirements before sector codes are formally published, the interesting question is, what if you have a sector code, but it doesn't comply with one or both of these principles, and there's a few others as well. What does that mean? It's an open question. One of the concerns and why interpretation is an issue in the triple BEE regime is because there's a lack of particular judicial authority. There's very few cases that give us guidance as to how one interprets a lot of these things. So I'm curious to see what happens when the sector code may be challenged on the basis that it's not required, it's not consistent enough, certainly in relation to these principles with generic codes. The other, again, this is just the amplification of what the statement provides, is that where you deviate from targets and weightings and thresholds or introduce new elements, you can only do so where this is justifiable based on sound economic principles, sectoral characteristics, or empirical research. Now, it's not always obvious, certainly when a sector code is published, that this exercise has been done, and presumably the Line Ministry and DTICC will do the assessment, as well as the stakeholders who promote the particular sector code. But again, it's sometimes not that obvious that there are, for example, sectoral characteristics or sound economic principles for deviations under sector codes. Interestingly, also, Statement 003 provides that sector codes must set targets above the minimum set out in the generic codes. This does happen with some sector codes, but it's not always consistent in sector codes. Okay, sector charter councils, right? So I mentioned them before, but their primary role is to develop sector codes and monitor compliance and implementation with the sector code. They can provide guidance and often do indicate in those sector codes that they will, and that they do actually sometimes provide guidance, although sometimes it's inconsistent. There are some sector charter councils that are quite good, that generally try and provide as much guidance as they can, and in those that are, silent or very, or sometimes you don't really get a good sense that there is a clear implementation or interpretive guideline on particular issues. They must report to the Minister and the Advisory Council, which is the BEE Advisory Council, on progress, which is probably why a lot of them would require progress reporting to be done, because they have a legal duty under this particular statement to ensure that they keep the Minister and the Advisory Council, informed. And this is obviously from a policy perspective to see to what extent triple BEE implementation is taking place, and if there are any issues and if there are any policy direction that is needed to ensure change. They can also share information with inter alia the triple BEE Commission. So that's important to note that they have that particular right. And then they must require the submission of BEE certificates and reports. So unlike the generic codes, where there's no or even in the Act, there's no specific requirement for you to provide or for a general repository in relation to BEE certificates, although there are mechanisms to do that. DTIC, I think, has one, or indicated that it would have one, as well as I know that the Triple BEE Commission also has a repository for certificates. In the case of sector codes and sector charters, you have to, if you're part of a sector council, you must provide a copy of your triple BEE certificate. I've been asked a question, and I think I'll address it quickly. When a sector code provides that you have to submit your triple BEE certificates and your triple BEE reports that go with those certificates, the general principle is you can only do so if you actually are complying. I think the principle is sector codes are not really different to the generic codes, in the sense that generic codes are not binding or compulsory on anybody. So if you don't have any BBE compliance and you don't intend to do so, I mean, the reporting requirement there would be just to say that you obviously don't need to, or you certainly shouldn't be compelled to obtain a verification certificate or undergo a triple BEE verification exercise if you don't intend to comply with the Act, even if you're in a sector code. That being said, sectors can obviously in various ways try and encourage compliance, and that is in fact their function. Okay, let's deal with Statement 100, which is the code dealing with ownership. Okay, Black ownership of companies. As I mentioned before, the most important principle around this is that you have to be able to trace participants. So in a company chain where there's lots of entities involved, you always start at the bottom and you go all the way up, and you look to find the natural person who's actually the ultimate owner. It's difficult sometimes in the case of vehicles where it's indistinct as to who the owners are, but that is the principle, and I still find that in practice people tend to ignore this particular requirement, or because it's often difficult that you can't always do it. They don't always comply strictly with it, but it's the starting point of all BEE measurement. You must actually trace the Black ownership to a natural person in order to evidence Black ownership. Now, rights of ownership is a concept defined in the codes in Schedule 1 as collectively the two concepts of voting rights and economic interest. In the context of a company, it's really that the shares or the equity in that company that would confer or be treated as conferring rights of ownership. We'll talk a little bit about specifically voting rights and some of the issues that come up in that context a bit later, and how one attributes voting rights to natural people who don't specifically have voting rights in a company. Voting rights, as I said before, don't need to be exercised by a participant, and that's particularly the case in collective enterprises. The DTIC issued a practice note. I'll talk about it in a little while, which clarified this aspect, because it was quite a, I won't say contentious point, but became quite difficult to apply because of the first rule that you have to trace participants and you have to be able to attribute voting rights. What seems to be reasonably clear now is that one can attribute voting to members, for example, of a trust, which is either a BBOS or even an ESOP, even though they don't particularly have voting rights to vote the actual shares in the legal entity, which is the measured entity being controlled. Economic interest is also sometimes difficult to interpret. I think what now also being clarified, and I think is fairly clear, is that your right to an economic interest is just that, it's a right. It doesn't have to be actual economic interest that flows. So for example, if you own a share in a company, you have the right to dividends, as long as that right to dividends is not restricted in any way or undermined in any way. That will be sufficient for you to claim the right to economic interest. You don't actually have to show that there has been dividends actually declared or you've actually earned any money. It's more about the right to receive it and whether or not that right is restricted. The other thing which I want to just mention in the context of ownership is when you're using collective enterprises, that's broad-based ownership schemes and employee share ownership plans or ESOPs, and trusts. There are additional requirements because the basic rule is these entities can only contribute 40% of the ownership points on a scorecard. So if you want to use these vehicles to claim 100% of the ownership points, so for example, if you have a trust that owns 100% of the shares in a company, it won't necessarily get all of the points, only 40% of the points if it doesn't have the additional, if it doesn't comply with additional requirements. Additional requirements are different for each of the collective enterprises and trusts, but maybe to mention in the context of trust, you essentially need what's called a competent persons report, which is an independent person who certifies that the trust was created for legitimate reason and wasn't established to circumvent or otherwise undermine the BEE codes. People often forget or don't consider this requirement carefully, and sometimes when we look at things and we have to consider whether or not there's been full compliance and whether example, if there's fronting, this is not really a fronting indicator, but it does mean that you may be limited to your ownership score if you don't make sure you comply with those requirements. Okay, puts, calls, and compulsory options. These occur typically in transactions, in ownership transactions, where you'll find people who generally try and ensure that they have some right to either acquire the shares back or put the shares to others, or even something like forced sale options in shareholders agreements are quite often. As a general rule, these are fine, except that where you have a system, and one goes back to the principle of substance over form, where you, for example, have a call option. You issue shares to a black shareholder, but then you issue it, let's say, for a nominal value, and then you have a call option to acquire those shares at any time for that nominal value. That particular construction is probably going to be a fronting exercise or fronting practice, and the reason is that you are effectively undermining the objectives, and you're not really giving effect to ownership, because if you are in a position to always ever claim those shares back, and importantly for no value or for low value, there wouldn't have been any opportunity really for the ownership principles to be established in that particular circumstance. The continued recognition principle still exists in the codes. Essentially, that provides that you can claim a portion of your black ownership even where, you can claim a portion of your black ownership where a black shareholder has exited. It is used still quite a lot. The important thing, which I think people sometimes forget in this particular principle, is you can only claim that ownership for as long as you had the black ownership. So, for example, if the black ownership was in place for 3 years, you can only continue claiming that continued recognition of a portion of that ownership for 3 years. And sometimes you find that in practice, people tend to forget that that's the rule, and people claim it for longer than is necessary. Okay, the modified flow-through principle is a principle which applies to 51% black-owned entity in a chain, and it provides that in that you can treat that entity as 100% black-owned. But the important thing is it cannot apply when the exclusion principle applies. The exclusion principle is where you exclude the ownership of state entities, importantly, and then certain other types of entities, like also other types of investments, like mandated investments of pension funds, etc. In those cases, though, pension funds, etc., you can actually attribute ownership by using a competent person's report again. So a competent person, again, so there was a question now raised. A competent person is essentially an independent person which goes about and tries to verify, in this context, the extent to which there are black ownership. So, for example, if you have a BBOS, a broad-based ownership scheme, and that particular scheme is directed at let's say it provides bursaries to black people, then you won't necessarily have all the individuals listed, so you can't really trace the ownership, or you may change it from time to time. So what you would do is you get a competent person to actually try and ascertain to what extent black rights of ownership actually flow through to people. The other important part about the modified flow-through principle is that it's actually quite limited application. You can only get 4 out of the 25 points in the ownership scorecard, and that's because it only applies to the first 2 parts, which is literally just your black ownership rights and your economic interest rights. You cannot apply it for black women ownership, and it also doesn't apply to the net value calculation. So it's quite a limited principle. The other aspect of it, which I see sometimes people don't always get right, is it can only be applied once in a chain. So if you have a company that owns, that is 51% black owned, and it owns another company, it can only be applied in relation to the company that it owns, and not below that or even above that. And that sometimes does mean that people get it wrong. Okay, enterprise and supplier development. See, we're running out of time quite quickly here. Okay, 51% black-owned enterprises. So in the codes themselves, EMEs and QSEs must be measured using the flow-through principle for purpose of qualifying as beneficiary enterprises for enterprise and supplier development. But it's not clear if that same rule applies for procurement, because the definition of 51% black-owned enterprises doesn't refer to that one must apply the flow-through principle. In fact, it's absent. It's only in the wording of Statement 400 when it comes to enterprise and supplier development that you see that they actually say the flow-through principle must apply. So that does mean that 51% large or generic enterprises can actually possibly apply the modified flow-through principle, and for purpose of procurement under the procurement element of the ESD scorecard can claim points. Enterprise development and ST. So supplier development. The difference between supplier development and enterprise development should be obvious, but I see some people still get it confused. Supplier development is for suppliers, and enterprise development is for non-suppliers, the general rule. Enterprise development can include suppliers as well, but you cannot double count. So you cannot claim the same benefit twice. So I've mentioned this before. Generally, this only applies to 51% Black-owned EMEs and QSEs. But what they did was they changed the codes to actually provide now that you can, at large enterprises, can also benefit out of this principle. So if you have, for example, a QSE, which was a beneficiary for, or was it, which a 51% Black-owned QSE, which was a supplier development or enterprise development beneficiary, that entity now, even if it becomes a large enterprise, can still, for a maximum period of 5 years, qualify as if it was an enterprise, as if it was a Black-owned, 51% Black-owned QSE or EME. So that's quite interesting. Also, it caters that procurement spend can be recognized as if you were EME or QSE, but again, only for 5 years. The other thing which is, I think, which comes up sometimes in practice and which is important, is only enterprise and supply development, which is payable at the date of measurement, qualifies. Because what sometimes happens is you're under pressure at the end of your year end, and you need the points for enterprise development or supply development, but then you say, okay, well, how can I quickly achieve it? And you pay it over to somebody to do the enterprise development on your behalf. Now that's allowed. The codes do cater for that, but the reality is that you have to, the spend has to have been incurred. So unless that entity you're paying it to is also an enterprise or supply development beneficiary, it's unlikely that that spend will be regarded as enterprise or supply development. Total measured procurement spend. One of the inclusions. One of the principles is you don't apply, or you don't look at salaries and wages. However, it also says that, you know, what is included in PMPS is pension and medical aid. Now, again, it's a bit curious because most companies actually, when doing salaries or remuneration, would include pensions and medical aid as part of the package. So just for clarification, I think the exclusion would be if your salaries or your remuneration includes pension and medical aid, there's no need to then include it back into TMPS for purpose of your calculation. Independence of an enterprise development or supplier development beneficiary, there's no requirement that it has to be an independent entity, but the implication is, again, looking at substance over form, that this has to be a separate entity which is run and managed and it's on its own. You can't have an entity which you control via whatever mechanism and then claim that that's an enterprise or supplier development beneficiary. That does sometimes come up, and the rules can get quite tricky around, you know, how far you can go. It doesn't exclude you owning a share in a supplier or even an enterprise development. In fact, it allows for investments into those entities. But I think to the extent that you want to exercise control over these entities, you might have issues. Okay, I'm quickly try and go through the practice note. Okay, the most important thing around the practice note is the definition of Black children and whether or not Black children can benefit under the codes. So this has been clarified in the clarification note, but in the context of collective enterprises. So those are BBOSs and ESOPs. Probably less likely in the context of ESOPs because those are for employees and yeah, I think we still have a law prohibiting child labor. So when it comes to direct ownership, that's not mentioned in the clarification note, but the principle, I think, should be the same. Black children should be entitled to benefit. And when I talk about Black children here, or children in particular, I'm talking about people over 7 years old, because under 7, you know, they're not really regarded as having any legal capacity. But the clarification note importantly has indicated that where you have children in a broad-based ownership scheme, those, or Black children, those can qualify. Now there has been, I know the BE Commission still has some concerns around this, and it's a bit of a difficult road to navigate in this, and every particular, or you have to look at the particular facts and circumstances around all of this. But the principle is that you should be able to claim rights of ownership even where there are Black children who are the ultimate beneficiaries. The attributing of voting rights we've discussed before, but essentially this means that you can attribute the voting rights to the beneficiaries of, for example, a trust, even though those beneficiaries don't actually have an exercisable voting right. Bear in mind, in the context of a trust, it is the trustee, or what's called the fiduciary, who votes the rights of the beneficiaries on behalf of the beneficiary. Hence, those voting rights can actually be attributed to the Black beneficiaries or the participants. The clarification that now also opens or paves the way for perpetual, what's called evergreen ESOPs. And essentially what this means is you don't have to have, you can, the structure, the structure can exist in perpetuity, and you don't always have to have the same employees. I mean, in the context of an employment scheme, employees come and go. So I suppose this was an important clarification around how one measures black ownership there, because it will essentially change over time, but you can have a structure that can exist in perpetuity. I've explained individual participation rights because you can actually attribute them in the case of collective enterprises. Also, another point which has been clarified is the discretion of fiduciaries. There has been some issues in the past about whether or not, because the codes do require the trustees to not have a discretion in relation to things like allocation of benefit or determining the rights of participants. That's now also been clarified, that discretion that trustees may have, in relation to allocation is fine, provided that the document or the founding document, like the trust deed, actually specifies how much these people actually own, or how much black people are entitled to. Okay, the other thing is important, is doesn't only mean that you have to have economic or cash flow. You can also do contributions in kind, which can include skills development spend as well. In the context of economic interest, as I mentioned, dividends, it's the entitlement and not necessarily the payment. And then lastly, 13G, sorry, I missed over that. 13G is simply, it's not simply, it's a reporting requirements under the Act. It also clarifies that where you don't have the necessary detail to perform a reporting application, this is in the context of listed companies, which are required to report on their BBBEE. And if you have, for example, a collective enterprise, and you can't necessarily delineate between all of the different categories, age, gender, race, etc., you can simply just report holistically. Okay, sorry, I know went a bit over. I've got questions, but I don't think we've got time. Maybe if I can just, if there are people on the, maybe I can just, so we will be sharing the slides. Just check if there's any questions here. So the one question on TNPS, if you're a consultant or labor broker, can you include the service charge in TNPS? I'm not sure what the service charge is, but as a general principle, that if you're a company and you're paying a labor broker, that entire expenditure would be in TNPS. In order to include supply in the procurement spend, we would need to have verified fee level through a valid certificate. Yes, that's correct. Okay, so again, mandated investments at the pension fund. If you don't have a competent person's report, then you can choose to exclude that mandated investment. So that's the exclusion principle. So mandated investments, because it's, take the example of a pension fund, you can exclude that up to 40% from your scorecard. But if you want to have it recognized, then you need a competent person's report, which will estimate the rights of black ownership through that mandated investment. The trustees of the trust cannot be regarded as a competent person. You need an independent person. Shareholders agreement verified by. So the question was, is it recommended that a shareholders agreement be reviewed by the BE verification agents as well as prior to submission to shareholder for signature? I think yes, that's important. I think in fact you have to do it. The verification guide requires all documentation to be made available to people, to the verification agencies to conduct the exercise. They won't be able to do a verification if they don't have your shareholders agreement, your MOI, and all the other information they need to actually conduct it. Okay, I think we've gone over time. I think I've answered most of it. We will be sharing the slides and the recording. And if you've got additional queries, you can direct it at us or to us. Thanks, everybody. I think we're going to close that.